Start. The learned senior counsel, appearing for the appellant/original plaintiff, submitted that what was executed on 1st December 1945 by the original owner was a will. He submitted that as the suit property is in Chennai, rights can be claimed based on the will only if a probate or letters of administration is obtained. The learned counsel submitted that in the absence of probate or letters of administration, no right could be claimed based on the so-called settlement deed dated 1st December 1945. Consequently, no right, title or interest in the suit property has been passed on to the third and fourth defendants by the sale deed dated 29th January 2001. He submitted that the continuous possession of the plaintiff is at least from 1951, and on facts, the plaintiff had established the plea of adverse possession. He submitted that the defendants have no right concerning the suit property, and hence, the impugned judgment is entirely erroneous. The learned counsel, appearing for the respondents, supported the impugned decision of the High Court. As far as the suit filed by the plaintiff for the declaration of ownership based on adverse possession is concerned, the plaintiff can never succeed unless he proves the plea of adverse possession. There is a concurrent finding of fact on this issue against the plaintiff. A plea of adverse possession is founded on the acceptance that ownership of the property vests in another against whom the claimant asserts a possession adverse to the title of the other. Possession is adverse in the sense that it is contrary to the acknowledged title in the other person against whom it is claimed. Evidently, therefore, the plaintiffs in suit number 4 ought to be cognizant of the fact that any claim of adverse possession against the Hindus or the temple would amount to an acceptance of a title in the latter. Dr. Dhawan has submitted that this plea is a subsidiary or alternate plea upon which it is not necessary for the plaintiffs to stand in the event that their main plea on title is held to be established on evidence. It becomes then necessary to assess as to whether the claim of adverse possession has been established. A person who sets up a plea of adverse possession must establish both possession which is peaceful, open, and continuous possession which meets the requirement of being nec claim and nec precario.